shall discuss mandatory interlocutory injunctions in the Irish law of equity. The Redlands Brick case in Morris in the 1970s confirmed that a court requires incredibly strong evidence of the future of grave damage to grant a mandatory injunction, as in this case, which concerned a injunction to restore land that had subsided due to historical quarrying activities, would have exceeded the cost of restoration as opposed to the potential for damage. The court therefore refused the injunction, providing that in common law there was a very high threshold to secure a mandatory interlocutory injunction. The Shepherd's Home and Sandham case in the 70s was a case concerning the reluctance to grant an injunction at an interlocutory stage by the court. And a court, in common law, ought to be assured totally and comfortably that an injunction was correctly granted at a trial, which is a stricter standard compared to the prohibitory injunctions and another available form of injunctions for the courts, prohibiting certain conduct. Campus Oil Limited and Minister for Industry and Energy Ireland was a case from the 1980s where the applicants sought a mandatory interlocutory injunction to secure compliance with oil supply legislation. Again, the courts confirmed that so as to be satisfied that an interlocutory and mandatory injunction is appropriate, there must be a high degree of assurance and consider special factors, including overall compliance with the law. The Reed and HSE case is a recent High Court ruling concerning mandatory interlocutory injunctions in Ireland, where the High Court was adjudicating over a petition brought forward by professionals in the Health Service Executive seeking such orders to prevent changes in dental service terms. As the case was about conserving and preserving the status quo, they, they sought to apply the principles of Campus Oil, and the applicants successfully established a fair question to be tried, and therefore the interlocutory injunction, mandatory in nature, is in a direction from the court to stop until a full hearing can be heard. The Boyhan Tribunal of Inquiry 2012 case of the Irish High Court concerned the application for a mandatory interlocutory injunction for a full legal representation in an inquiry, provided for in primary legislation. A mandatory injunction at this interlocutory stage required a strong case for success at trial, and therefore it is a pre-trial hearing on which the courts will make a decision on a case-by-case basis. The Lingham and Health Service Executive case of 2012 in the Irish High Court concerned a applicant seeking interlocutory injunction for mandatory relief against the health service, and the applicant must demonstrate a strong case so as to obtain this order when seeking mandatory injunction. Therefore, the burden of proof is placed upon the applicant for the courts to issue such a order. The Films and Rover Limited and Canon Film Sales Limited case of the 1980s is a common law case concerning the involvement of risk of injustice in granting an interlocutory injunction of a mandatory nature. Therefore, courts at the common law ought to consider what course carries the least risk of injustice if the injunction is ultimately found to be wrongly granted. The courts must consider if a mandatory interlocutory injunction is granted, would this be of lesser or greater injustice than if the interlocutory injunction is not granted, and the courts ought to make a decision accordingly in common law on this basis. In Cronin and Minister of Education and Science, the 2012 High Court case considered a parent seeking a mandatory interlocutory injunction requiring the attesting minister, therefore the respondent, to provide special tuition for a child. The courts directed that the applicant ought establish a genuine or bona fide issue, and therefore a higher burden exists on the applicant due to the mandatory nature of the relief being sought by the applicant. Now, Hawkes and the National Institute of By pressing research and training, the 2012 High Court case considered the standard of proof for a mandatory interlocutory injunction, thus reaffirming by the court that applicants must demonstrate a strong case to obtain interlocutory relief when seeking mandatory injunctions. Shelburne Hotel Holdings and the Torium Hotel Operating Company is a 2012 High Court case where the plaintiff sought an interlocutory injunction directing a defendant respondent to provide certain financial information. The courts considered that whichever course provides the least risk of injustice is the injunctible course that the courts shall take, and ultimately, if there exists a lower risk of justice, if the injunction is ultimately found to be wrongly granted. The Bergen and Galway Clinic Dugiska case of the High Court found that a case concerning an employee seeking to prevent dismissal or a process leading to same in a mandatory interlocutory injunction. The courts reaffirmed that the applicant, and in this case the employee, ought to establish a strong case to obtain such relief, as the injunction seeks to continue a contract of employment and therefore maintain a status quo.